Ann and I, we were just talking about how long we've been at doing D&O insurance, and it's a long time. And we've picked a few topics that we hope. Can I move this forward? Just the clicker? Can I just do this? I can do that. Those are nice pictures of us.
Yeah, that's an old picture I made, by the way.
Well, it's good that. Well, that's old too. There's more dark hair here that we like. But we picked 4 issues that we thought would be topical. We hope we have a discussion about these. When Ann and I first talked about this session, we thought there's a lot going on in AI. And then Jamie said, no, I'm going to do AI, don't you do AI, Bill. So we put the AI topics aside. But there are a lot of AI topics to deal with in the D&O liability and insurance space. And one topic that is kind of AI related that didn't come up is something called quantum computing. And when my kids were younger, when my oldest was about 5 or 6, there was a 5 or 6-year-old next door. His name was Duke. And my son and he were playing together, and my son was doing some math problems. 2 plus 2 is 4, 5 plus 5 is 10. And Duke, the kid next door, was multiplying he's 5 years old, multiplying and dividing 4-digit numbers in his head, which I had to get out a calculator to confirm, and he was right. And Duke is now an astrophysicist who actually understands what quantum means and what quantum computing means. But quantum computing is an entirely different way of processing computer power. And why is it important? And why is it important for D&O risk? If you believe the people who are saying, oh, it's a terrible thing, it's possible that quantum computing could cause all of the cryptography that we're currently using to be breakable. So all of the cryptography that's being used to secure banking transactions, and the cryptography that's being used for your virtual private network at the office, and the cryptography that's used to store data at rest. And there's an issue related to this for cyber breaches. You can avoid a cyber breach if you have adequate encryption of data, and that encrypted data is misplaced or stolen. If it's adequately encrypted, there are some statutes that say it's not a breach. Well, with quantum computing, if all of and this is what the people who know about this topic are worried about, it's possible that transactions are being recorded now, they are encrypted now, and that encryption using standard computers, not quantum computers, is essentially unbreakable. It would take 100 years, 1,000 years using the fastest standard computers to break the encryption algorithms. Using quantum encryption algorithms, the mathematical theorists tell us, and you'd have to believe them, that when quantum computing gets to a certain level of technological development, it will be possible to take those unbreakable cryptographic locks and unlock that data in an hour, 2 hours, or a day. So quantum computing presents one of those issues where things that we think of as secure now become insecure because of a technological development that, if it hasn't happened now, it's very likely to happen in the next 5 years. And when I think back to when we started practicing, and this is funny, my assistant used to take longhand steno, which is funny to even think about, and I had no computer on my desk. And the world has completely changed, and I believe that each decade since then has increased in speed, and this problem is going to make us have to change our whole information infrastructure.
Well, and maybe we should be changing some things now So right now, some of you may be familiar with the phrase, harvest now, decrypt later. Anybody familiar with that? Okay. This means that the hackers are going in now and snatching up the encrypted information, and they're patient. They're going to wait for the decrypting tools, the quantum, to come about, but they're holding that data. Maybe it's intellectual property. Maybe it's the keys to your kingdom. So the fact that they can't decrypt it now using standard tools, but anticipate that quantum computing in the next few years will make it possible, means that there are black hats right now breaking into your safe and taking out, harvesting now, your encrypted important information, the keys to your kingdom, so that in 2, 3, 4 years, they can decrypt it, and if it's still important, then they can monetize it. And does anybody know that this is happening? That's the thing with stealing data. You're stealing a copy of it. And as long as you don't leave your fingerprints all over it, no one knows it's been stolen. So what are you to do? What are those in the risk management field to do? Is there anything that can be done? Well, there are some algorithms that we could be using that make themselves more decryption remote, more difficult. So there's a number of different decryptions that you could use. Some of them to fight this harvest now, decrypt
so if
later.
I'm an officer of a public company, do I have an obligation now to be doing that?
Do you even understand AI? And then quantum computing is, a step beyond that. So I read an article the other day that said, should boards have an expert on the board of directors who understands AI, if AI is really intrinsic to what they do, how they deliver their services, what the goods or services are, should they have someone on? And the conclusion was, well, maybe it would be nice, but how many of these people are walking around right now who could sit on the board of directors? Unless we're going to have each person on 20 or 50 boards, it's just not possible. So then take us a few years into the future, and not that far away, quantum computing will become reality. So I will share that I have a client. I love most of my clients, and they are a quantum computing firm. And they are right now working on their initial public offering, their IPO. So the odds are, sometime this year, their expectations is that they're going to be publicly listed because they believe that they're that close to the finish line. Now, my concerns are kind of, okay, we're going to have to sell this to the D&O insurance underwriters. And I had a client who had AI in their name in Q4, who an underwriter told me what they shouldn't have. And they said, if it has AI in the name, I, as a senior underwriter, cannot make a decision on writing them D&O insurance. I have to go up the food chain. AI is in the name. And I'm like, it's not in their name. And they're like, yeah, but if I go to their website, the first thing that it says is AI-driven. And that company, who was already on the account, got off, in spite of the underwriter repeatedly telling me, I'm pushing. We have a limited appetite, he said, in the underwriting community. So we don't need an exclusion. What we'll do is give thumbs up or thumbs down to that particular risk. And he said, and we all know the AI firms have been sucking the oxygen out of the room in terms of capital. Whether they're doing an IPO or they're doing some kind of fundraising, it makes it more difficult for every other company out there doing fundraising or doing an initial public offering because these AI firms have seized it. Now we're seeing the beginning, is what I'm suggesting, of the quantum computing firms who are going to look to do the same, and they're going to be cheek and jowl with all of the AI guys.
So this topic is kind of a look what's going to happen in the near. Yeah, it's a stay tuned topic. The next topic that Ann and I landed on is kind of the opposite end, and that's you have your D&O insurance policy. Do you have an alternative dispute resolution clause in it? Should you have an alternative dispute resolution clause, an ADR clause in it. Why would you have one? And what type of ADR clause should you have? And this is on one level, this is granular, and what should my current insurance policy look like? How will I resolve disputes? But the answers differ depending upon who you are and what your ethos is about how disputes with a business partner should be resolved, or what you anticipate. Is my dispute likely to be one that I think a court would look friendly upon or not? Or is it one that really is something that should be in arbitration? But what are your thoughts on it?
Reasonable people could disagree. We're both reasonable people. We both disagree. So the first session today was on coverage disputes. So this alternative dispute resolution mechanism is a provision in the policy that says if the carrier and the client disagree, then we're going to go to, then it will detail some form of alternative dispute resolution. I will share with you that the knee-jerk reaction in the insurance brokerage community, and I think there was a session on broker liability before, the knee-jerk reaction is get it out, get it out, get it out, get it out.
Entirely.
Entirely. Rip it out of the policy, delete that entire section, no questions asked. That's it.
Does anyone here have a view about that? Anyone have a view that I don't want an ADR clause in my D&O policy, or I do?
So when I start this off, I usually remind...
Marshall has a view.
Get it out.
Get it out.
Get it out. My start of the conversation,
Yes.
I think there's another person.
I think it depends on the specific wording of the ADR clause.
Yes, and that's going to be my second point, is you're exactly right. You can get whatever wording you want. And rather than rip it out wholesale, any carrier, I just had one carrier refuse, but they will give you virtually anything you want, and I'll tell you in a minute what I really like for my clients to have. But I start with the premise that most general counsels who I have spoken to require there to be an ADR provision in any contract that the company enters into. Now, they're thinking vendors. But an insurance carrier is a vendor to the insured under that policy. So I will say to my client, who I'm like, do you want me to take it out or do something else? And they're like, well, what do you think? And I said, go back to your general counsel and ask what they want. Do they want it in? Do they want it out? If they want it in, let's get what we want. So the first set of ADR that came out said, the insured gets to choose the manner, the type. Is this mediation or is it arbitration? And then it went on to say, and if either party is dissatisfied with the outcome, they can then bring this into a court of law. So it is not the end of the road, but it is perhaps the beginning. So the carrier that had rolled this out over 20 years ago, I said to them after a couple of years, how's it working out? And they said, we like it. Sometimes we win and we still settle with the client. We don't want to see them in court. We don't want to lose them. We got a chance to see how passionate they were about this issue and why they felt the way they did. And we wanted to keep them as a client because we're looking at cash flow in, cash flow out. We want cash flow coming in. So you can get a provision that says you are in the driving seat. You choose the type. You choose who pays the expenses. And if you don't like the outcome, you can be even-handed, either party. I said, how many times did you sue AIG? How many times did you sue your client after this? And they're like, never, because we didn't want discovery on what we're doing with the rest of our book of business, which was an honest response. So if you could take it out or get whatever you want, and I've only had one carrier say, no, it's either in or out. And I'm like, really? How does that make any sense? It benefits you, the insurer, and it's usually much quicker than any trial. It's usually cheaper, and as long as you can say, I will see you in court if you don't like the outcome, why, in my mind, is that not the optimum? But that's how I start the discussion. I don't just take it out. I speak to my contact and say, does your general counsel have this provision? Probably. And I don't want them to be surprised if there's any coverage dispute that they said, you know our rules, we're supposed to have this, make it happen. You could get whatever you wanted, including nighttime baseball arbitration. Look it up. That's a real thing. And we're going to move on because we don't want to take the thunder away from the ADR panel that will be after this. But it's not either or. Yeah, it's not either or. And you can fine tune it, tweak it, what would make it comfortable to you. You can't get it, take it out.
What interests me about this is if you'd asked me as a lawyer who is presented with these insurance policies as a finished product, after the fact, I don't often get to see the birthing.
Front end.
I see the undertaking. And when we see it as it's already created, I always assumed that the arbitration clause was something that the underwriter would insist on and would insist on in their form. But in today's market, that's something that is negotiable.
More often than not, it's yanked out. Wholesale. Gone. It's either in or it's out.
Because
We have a question.
yes.
I think there's something to be said. I'm a certified mediator. If you have a good mediator, there's something to be said about having a good mediator and having a clause like that, because sometimes, as a lawyer, you want people, the client doesn't understand. They're angry, they're upset. And you get a good mediator just their position as an independent, set of eyes. I've been in cases where the mediator has done a great job in convincing an insurance company to pay a claim, because the insurance company dug in its heels. They had a difficult attorney. I won't name who it is, but to the extent that the mediator did a great job in convincing the insurance company, the decision maker, to handle or to pay on the claim, it worked. So there's something to be said about mediation is simply about trying to come to an agreement, but trying to convince one side of how weak their position is.
And that's a people thing. That you have to convince the decision maker
Exactly.
that one side or the other has to compromise or both have to compromise. That's a human thing.
Especially when you're not down to a decision in the end anyway. So.
Yeah. So to me, it's not a binary question. There's what are you looking to achieve, and is there a way to get that? And if yanking it out is the best thing, then that can be done. But I'd try to negotiate your most favored word first. And we're talking about management liability policies. It may very well be different in GL or other types of liability contracts.
And one thing to note, I was surprised by a case in the Second Circuit, I think it was 2026, which is referenced in the materials that you have, in Ray Orion Health. And frankly, this surprised me. I've been doing this a long time, and this surprised me. The Second Circuit found that an arbitration clause in a D&O insurance policy, which is an insurance policy where the first named insured is the corporation, and then all the individual officers and directors are individual insureds, but that the arbitration clause, the dispute resolution clause, only applied as between the corporate insured and not as between the individual insureds and the insurance company, which meant in an insurance policy which limited the corporate insured to an ADR process, the individual insured was permitted to be in court, which is something I frankly hadn't seen before, but it's just out of the Second Circuit this year. And if you're in the business of advising individual insureds and the corporate insureds in these claims, it's something to keep in mind as something that's out there. I'd never seen it before, but it's the Second Circuit recently.
It was definitely eye-opening.
A couple of other issues, bump up and runoff. You want to do bump up?
So most people refer to this as a bump-up exclusion. I use the term bump-up wording because it's not in the exclusions. Today, it's in a definition of loss. So if you look at an exclusion section, you will occasionally in a D&O policy see it, but there's a reason why it got moved into the definitions. You heard that earlier panel on coverage disputes, and they said exclusions are construed narrowly. Yes, they are. So let's take it out of the exclusion section and stick it into definitions. The definition of loss will have a paragraph that's midway down the page that says, loss shall not include any increase in compensation paid in the M&A context. And then it will give you some parameters. You're acquiring someone else is acquiring you. Either or. One of your subsidiaries buys somebody, and there's a dispute about the price, and the other side is saying, the shareholders or stakeholders of that company is saying, you undervalued us, we need more money, and they sue to increase the purchase price, that bump up or increase in price as a result of the suit saying that the process was unfair, people didn't pay attention to their duty, their fiduciary duty, they didn't do the correct due diligence. So the number of mergers and acquisitions and divestitures happening right now are at a second all-time high. It's a second all-time high after last year, which itself was an all-time high. So there's a tremendous number of transactions happening right now. Maybe your firms are involved in there. Maybe you're on the buyer. Maybe you're on the seller. It started with these bump-up claims being made against the seller. You, as my board of directors, sold me up the river and didn't get enough compensation for us common shareholders or what have you. It has morphed over time to also going after the buyer, saying you are aiding and abetting the seller. So the bump-up wording is not an exclusion, although 9 out of 10 people refer to it as a bump-up exclusion. It appears in the definition of loss. It applies in the M&A context. There's an incredible number of these going on right now. There is a huge body of litigation, some of
For
which
probably
is
the last decade.
Some of it is helpful and some of it is not, because the language is not ISO. It's not the Insurance Services Organization, and it's been changing over time. So it's these decisions are very language dependent for the most part. So it lends us little foresight into how the next case may come down. So is there a lot of discussion about what the wording is in context of a D&O renewal? No, sadly. So very little consultation with the client on this subset of the definition of loss.
And it's not something that if you didn't know what you were looking for that you'd say, aha, there's the bump-up exclusion, because there isn't one.
Right. Clients will often say, tell me what exclusions I have in my policy. And I'll say, when you say exclusions, do you mean like exclusion section Roman numeral 4? Or do you mean limiting language which could totally eliminate coverage under your policy? Because that's littered throughout the policy, including the preamble before the policy proper starts.
And over the past 10 years or so, every 18 to 24 months, there'll be a case going one way and a case going the other way. And the most recent case I'm aware of is in the Supreme Court of Delaware in a case called Harmon. And it found that the bump-up exclusionary language did not exclude coverage, really based upon, more than anything else from my reading of the opinion, what the nature of the relief was. Because the exclusion says that you don't get the increase in compensation for the deal. And if that's the relief, the increase in compensation paid, if that's really what's being sought, then that's not part of loss. Except what the settlement in Harmon was to avoid the uncertainties of future litigation, we're settling this case. And one of the things the Delaware Supreme Court hung its hat on was that's not an increase in compensation, that's avoiding litigation expense. So there's details here, but if you have, this is a broker and policy reader issue. So Jed Rakoff in the Southern District of New York, in a case called AmTrust versus Forge, said this, 10 days ago?
And love him or hate him, Judge Rakoff certainly is
Judge
very
Rakoff
well
is
for being a controversial.
He's a great judge to be in front of, except when he's yelling at you. But what the subsequent acts exclusion says in this policy is, no coverage will be available under this policy for any claim based upon, arising out of, directly or indirectly resulting from, in consequence of, or in any way involving any wrongful act committed or allegedly committed on or after the date.
The transaction date.
So that's broad language, so broad that I'm imagining Judge Rakoff or his clerk thinking, well, this seems like they're trying to overly broadly apply this. How do I deal with this very broad policy language, excluding subsequent acts, and how do they deal with it?
So what Judge Rakoff said was the alleged wrongful act was delisting of some preferred shares. And the transaction date, they had delisted the common. and told everybody, hey, it's just the common shareholders. We're going to keep public market on the preferred. So that's the transaction date is when they go private on the common shares, but the preferred is still listed. Shortly after the shareholder vote for, yeah, go ahead, delist, was it 2 months? They delisted the preferred as well. And the suit says, you knew this all along. You fraudulently induced me into approving the deal, and then you sold me up the river by delisting my shares. Now I have no market. I have to take whatever I can get. And you know, this is a wrongful act. Well, when did it occur? The delisting happened after the transaction date. This wording says no coverage for anything smelling like, walks like, talks like.
And the court's opinion turns on an analysis of delisting.
Is delisting a wrongful act?
And saying, was delisting something that was a lawful corporate act? Was it a lawful corporate act? And since a lawful, in the court's opinion, a lawful corporate act can't be a wrongful act. So there's no wrongful act subsequent to the retroactive dates that would otherwise exclude these events. Therefore, the insurance company didn't show that coverage was excluded.
So the runoff policy paid the full claim, or would pay, or will pay, the full claim, including that act that occurred after the transaction date. So that may be a unique situation, but the language that I was describing, very akin to this, I saw in a policy at the end of last week. And I said, this is completely unacceptable. That's insane and not acceptable. Get this changed. And of course, my word is law, so they're out there negotiating that now. Thankfully, that all works well for us. I think we have...
We're done.
50 seconds.
No, we're 10 seconds over.
Oh, okay.
Thank you all very much.
Yeah.